appearing. She's appearing.
Yes. Item 12.
She appears to be on mute, my lord.
My lord, I am appearing in item 12.
Yes, please.
Yes, my lord. My lord, this is a GST refund writ petition, my lords. My lord, in the impugned order, the reliance has been placed on the earlier year's orders, which is already pending consideration in the writ petition before my lords, and it is coming up for hearing next Monday. If my lords are to see the impugned order annexed to P4.
Yes.
Yes, my lord. This starts at page 128.
Yes.
And my lord, relevant is page 138.
Yes.
Yes, my lord. Clause 138 in the middle of the page, it says that the department has already preferred an appeal before the Joint Commissioner on the same issue in taxpayer's own case. The additional commissioner has allowed the appeal on the following grounds, my lord. My lord, this order I have challenged before my lord in a writ petition because, my lord, this is an issue for every quarter. Every quarter I am being recharacterized as an intermediary, and every quarter my refund is getting rejected. So, my lord, this order is the first year which is pending before my lords. It is coming up for hearing on next Monday, my lords.
We'll keep it along with
Right, no, but that is an order in appeal. Against this order, she has an appeal. She's not reached that stage.
She knows the outcome of the fate of that. Your appellate authority is going to pass same order. We'll hear along with that WP. Which is that WP number, madam?
Yes, my lords. My lords, that is P5 I mentioned. My lords, writ petition 5621 of 2024.
Okay, jointly agreed. List this matter with WP 5621 of 24.
Yes, my lord. My lord's formal notice may be issued to my learned friend because in case he has to file a
is directed to take notice and file counter.
My lords, one more small request. My lords, I have also filed an IA seeking stay. And my lords, the reason why I put this request is because, my lords, every quarter, my lord, my refund is getting rejected basis this very reason. I have already filed 3 writ petitions. I am in the process of filing 3 more writ petitions before my lord. This is the right.
Madam, in previous 5621, counter has been filed?
Yes, my lord, counters filed. I have filed my written submissions also.
It will come on Monday. It's a pure legal issue. Let Mr. Fernandez in the meantime examine whether he will borrow that counter or not. If that counter serves your purpose, you may make a statement on that day.
Very well.
All right.
Please, my lord, then my IA may please be kept pending only. No order will be passed for that.
We have not disposed it of. Yes.
Right. Wait.
My lord, I have gone through the judgment L. Chandra Kumar versus Union of India. The appropriate forum is tribunal only, my lord.
You withdraw it, go before the tribunal.
Yes, my lord.
Because she such and such seeks to withdraw this petition with the liberty to file appropriate proceeding before Central Administrative Tribunal. Shri Mukherjee appearing for R1. For the respondents have no objection. Petition is dismissed as withdrawn with the liberty prayed for.
Publish.
Let them go before the tribunal and satisfy the tribunal. Yes.
Publish.
Yes.
My lordship, starting from where I left in the morning. My lordship, we have enclosed the appeal memorandum in the affidavit as exhibit P6, my lordship. From page number 30.
Your appeal was dismissed barred by time because it was barred by time.
Exactly.
Where is your appeal memo?
From the page number 39 to 45, my lordship.
P, annexure?
P6.
P6, my lordship.
P6.
Yes, my lordship.
In which paragraph you have explained the delay?
My lordship, please refer to the page number 43. Page number 43.
Yes.
It's an annexure to form appeal by my lordship.
You said 1 month.
Yes, ma'am. But in fact, there is no delay of 1 month, my lordship, considering the date of DRC 7, which was issued in the portal on 18/4/2023, my lordship.
In reason for delay, where you have said that you got information on such and such date, and therefore counting from that date, there is no delay.
Yes, my lordship, that's a part of our mistake, my lordship. But considering the DRC 7 days, there is no delay in filing the appeal.
You
memo.
yourself has said delay is 1 month in your appeal memo.
Yes, my lordship, that's a mistake on our part, my lordship. But as per
Where you
the,
have explained, if you are saying there is no delay, it means you are counting limitation from the date you have seen it in the portal.
yes, my lordship.
So where have you said that I came to know about the order only on such and such date through this mode?
My lordship, we have filed it in the affidavit, my lordship. We have mentioned it in the affidavit, my lordship.
This you are required to say before the appellate authority.
Yes, my lordship, but the appellate authority issued the personal hearings, but we haven't received any of the personal hearings, my lordship.
Where is the finding of appellate authority?
My lordship, it's an order in appeal, my lordship. Exhibit P1, my lordship. My lordship, please refer to the page number 18. 18. In the serial number 7, my lordship, paragraph 7.
The time limit is 3 months, Mr. Fernandez.
Yes, 3 months and he has.
3 plus 1.
Plus
3
1.
plus 1, my
Yes.
lordship.
So it is within 3 plus 1.
No, my lord.
Considering
Now
the date of DRC, my lordship, it is
What
filed
my
within the
friend-
2 months, my lordship.
What my friend is arguing, not from date of DRC 07. He is no way in the affidavit also averred that he has not received the order otherwise. The order is actually dated not on 30/11/2022, the impugned order, which they had to file an appeal against. He says that the DRC,
Mentioned that there were delay for reasons.
he does,
Mr. Fernandez, suppose we set aside this order, permit him to file an appropriate application for condonation of delay, then you decide it on merits.
I'll leave it to your lordship.
You know, we'll say that you supported this order.
Then, and let me get instructions, because sometimes it may become problematic.
No, we'll say that you supported the impugned
Supported
order.
the order, yes, yes.
You supported the
Supported.
impugned order, not supported his argument. Do you have any serious objection if we remand it back to appellate authority?
No, my lordship.
Shri, your name please,
Bharat Nandan, my lordship.
for the petitioner, Shri such and such for the respondent, with the consent finally heard, that this petition assails the order in appeal dated 19/7/24, which is dismissed on the ground of delay. Learned counsel for petitioner submits that while filing an appeal, the petitioner mentioned that there exists a delay of 1 month, but did not assign reasons for delay in detail. That in the interest of justice, the petitioner may be permitted to file an appropriate application for condonation of delay before the appellate authority, and in turn, said authority may be directed to decide the said application afresh in accordance with law. Shri Dominic Fernandez supported the impugned order dated, what is the date, Mr. Fernandez? 19/7/24, 19/7/24,
Yes.
and submits that there is no flaw in the order. Next, we have heard the parties that in the impugned order, it is mentioned that the petitioner has not mentioned about delay in filing the appeal. That this finding is factually incorrect. That the petitioner indeed informed that there exists a delay of 1 month. That the petitioner intends to assign reasons for the said delay. That if said innocuous prayer is allowed, no prejudice will be caused to the other side. That thus we are inclined to allow the said prayer and deem it proper to set aside the order dated 19/7/24. That the petitioner shall file appropriate application for condonation of delay within 15 days from today, failing which said application shall not be entertained. That if application aforesaid is filed within aforesaid time, the appellate authority shall rehear the petitioner on the said application and pass order in accordance with law. The petition is disposed of without expressing any opinion on the merits of the case.
Obliged, my lord.
Obliged, my lordship.
My lord, I have to, the counter has not been served on us yet.
Your Lordship, this is a case where my lord petitioner has filed a writ petition seeking directions to the magistrate who.
Can we use microphone?
This is the writ petition filed, my lord, seeking directions from the Honorable Court to initiate disciplinary proceedings against the magistrate, where he contended that some loopholes are there in rendering the judgment. The matter was placed before the acting Chief Justice, and acting Chief Justice opined that, my lord, it is a matter for a courts of appeal to pursue his remedies. That is the reason why they did not entertain it, my lord. By one more thing, my lord, your lordships may kindly see against whom he is asking to take action at the time of filing.
Yes. Yes, please.
At
Yes,
the time of filing writ petition, he was 64 in 80. By a flex of time, the cause does not survive, my lord.
What is your prayer in the petition?
Prayer is, my lord, is Honorable Court may please it to issue an appropriate writ or the direction, more particularly in the nature of writ of mandamus, directing the first, second, third, and fourth respondent to refer the complaint dated 31/1/2018, lodged by the petitioner complaining of the corruption against the fifth respondent subordinate judicial officer, along with the entire material connected therewith, the relevant thereto. The full court consisting of all the learned judges of the Honorable High Court at Hyderabad, or at least to the disciplinary committee
This is
complaint.
arising out of any particular judicial order.
Yes, Your Lordship.
Which is that judicial
No,
order?
Rakesh Sanghi is supposed to argue this matter. I request, Mr. Sanghi is going to argue this matter, Your Lordship.
Which is that particular order?
I don't,
Because of which
I'm
you are
not
making
aware of-
such allegation against respondent number 5? And the respondent number
It is
5,
in CC, my
kindly have
lord,
it tomorrow,
page number
Lordship.
18.
Kindly have
see,
it,
respondent number 5 must have retired by now.
yes, Your Lordship.
He was retired by then only.
Yes, at that point of time. 64.
What action can, disciplinary action even cannot be taken against him
I'll
now
seek
under the rules.
Yes, I'll seek instruction.
You unnecessarily-
I'll leave it to Your Lordship.
Application Shri such and such for the petitioner, such and such for the respondents. In this petition, petitioner has prayed for following relief. Page number 16, bracket to bracket, 16 to 17. Next, a plain reading of prayer clause makes it clear that no specific order oblique judgment of fifth respondent is called in question. In absence of finding any fault in the said order oblique judgment, no directions can be, no consequential directions to proceed against a judicial officer can be passed. Apart from that, the cause, apart from this, the details of fifth respondent shows that in the year 2018 itself, he was 64 years of age. No disciplinary proceedings at this stage, even otherwise, can be initiated against a retired judicial officer. The prayer is vague and ambiguous. No relief is due to the petitioner. Thus, apart from this, learned counsel, you are appealing for respondent number?
Respondent number 2, 3, and 4, my lord.
Apart from this, learned counsel for MS such and such, learned counsel for
Right.
respondent 2, 3 and 5.
5, my lord.
2, 3 and 5.
And 4, my lord.
2, 3, 4 and 2, 3 and 4.
4.
2, 3 and 4 informs that the complaint regarding alleged conduct of respondent number 5 was placed before the then acting Chief Justice, who opined that if petitioner is aggrieved by any particular order of respondent number 5, he may avail the remedy of appeal. For these cumulative reasons, we find no justification to entertain and keep this matter on the dockets of this court. Petition fails and is hereby dismissed. contract must be over.
Court officer. Court officer. Court officer.
Yes.
My lord, they are now discussing the case law.
No, is it your case that they have exceeded quota?
No, quota they might not have. But showing 70% of the people as a bunch against.
How you are affected? How your rights are affected?
My lord, what I am trying to say is, they were appointed in 2017 or so,
Yes.
promoted in 2017.
Yes.
All 70% are being shown above me.
Yes.
This is what, my lord, again kindly read at, the page 67.
Yes.
They say that they cannot be placed as a bunch if there is a rule for quota and rota. Quota is, my lord, your percentage, 30%, 70%.
Yes. Yes.
Rota is, my lord, first
Rule of reservation or roster.
roster, that is, first vacancy goes to so and so, second vacancy goes to so and so, third vacancy.
What is the rota here?
1, 4 and 7 go to direct recruits. Again,
1, 4 and 7. Yes. Yes. Right.
1, 4 and 7 go to direct recruits.
recruit. Yes.
Supposing, my lord, you
That is the case. They cannot promote as a bunch.
as a bunch.
But
This is what the
because they have to
honorable,
follow that principle. Then only.
then this just arrange. This is what, my lord, supposing, my lord, they say that around 96 promotions were given
Yes.
in 2022.
Yes.
And 96 persons, my lord, and they were given 2017 as the year. 96 persons come above me.
In violation of that principle, you are saying
That
cycle.
principle.
Yes.
This is what Honorable Supreme Court says. Can
Yes.
I, page 67, my lord, kindly see
Yes.
that,
Yes.
that by getting appointment order. Your Lordship,
Right. Yes. Yes.
that your lordship have read.
Promote is en bloc above the direct recruit.
En bloc cannot be placed. This is the submission that I make.
Especially when
Then
both of them were selected against the same requisition sent by the government.
That's what. But especially, that's what they say. Even otherwise, that is the position. My lord, kindly go to page 68.
Yes.
They come to the case law.
Yes.
In Gonala Bhimappa, your lord gets that page
Yes.
68. State of Karnataka and others, this court held as under. It is well settled proposition of law that where recruitment is from two sources to a service, a quota rule can.
Para 8 you are really?
Yes, madam.
Para 8.
Yes, madam.
It is well settled position of law.
Yes, madam. Two sources, a quota rule can be applied, fixing the limits of recruitment from the.
Read from the top, page 8 onwards. It is well settled position in the law.
Yes, madam. That is
Yes.
only read.
Yes, read.
It is well settled position in law that where recruitment is from two sources to a service, a quota rule can be applied, fixing the limits of recruitment from two sources.
Yes.
In Badami, so it's referred to several authorities of the court and clearly drew out the judicial consensus on the point in issue by concluding that quota rule had to be strictly enforced and it was not open to the authorities to meddle with it on the ground of administrative exigencies. Then 11, scheme in force relating to the services for fixing interstate seniority takes into account the filling up of the vacancies in the service from the two sources on the basis of the quota, and therefore fixation of interstate seniority in gradation list has to be worked out on the basis of the quota. In a precedent-bound judicial system, binding authorities have to be respected. Kindly omit that particular portion.
Yes.
Then, my lord, several authorities were cited. Then, my lord, kindly come to page 70. Can I read? In
Yes.
service jurisprudence,
Yes, sir.
persons who possess the requisite qualifications for being appointed to a particular post, and then he is appointed with the approval and consultation of the appropriate authority and continues to be fairly long period, then such an appointment, this is the contention of the promotees,
Yes.
cannot be held to be stopgap or fortuitous or purely ad hoc. These judgments, in our opinion, are not only distinguishable on facts, but also on law. In the above cases, issues with regard to the year of vacancy and seniority in accordance with the date of appointment was in question. The argument advanced by the counsel for the contesting respondents has no merits and substance. The action of the authorities is based on the misinterpretation of the provisions of Rule 21 of 1976 rules and is therefore liable to be set aside. The action of the authorities is also contrary to the register prescribed for the purpose of appointment to the PCS officers. The mandate of the roster is that unless the appointment in the order prescribed is rota. Order prescribed.
Yes.
One second. Order prescribed under Rule 18, the appointment is invalid. Consequently, the order of appointment must be deemed to be the order prescribed in Rule 18 of 1976 rules. The action of the respondents in determining seniority list without reference to the order consequence of appointment is wholly unsustainable in law and is liable to be set aside. This apart, the term order of appointment is also being misinterpreted by the authorities and is being confined to individual orders of appointments issued to the individual members of the service, whereas the term appointment refers only to the order of the consequence prescribed under the Rule 18. Further, from a perusal of Rule 21, would it be manifestly clear that if it is to be interpreted in the manner in which it is presently being done, namely to determine the seniority on the basis of the order of appointment, that is, the date on which order of appointment is issued, the same must necessarily relate to inter se seniority of the individual sources of recruitment. This procedure was adopted in preparing the seniority list confined to Register B. Action of the authorities in determining the seniority of all members of PCS EB with reference to their date of appointment, that is their direct recruits, and not with reference to the order by which they were required to be appointed. That is 147. I do not know whether I could. They were appointed, in my case, I was appointed on 19-1. The learned judges say that don't take that date. The order is prescribed in the rules. First vacancy or second vacancy, whatever is the vacancy that I should get. I should get seniority based on that. This is what it says, my lord. This procedure was adopted in preparing the seniority list.
You are not giving the dates of promotions of unofficial respondents. When were they promoted?
They were shown to have been promoted, my lord, with effect from 1/2/2007 by giving promotion.
2007.
17 by giving promotions, my lord. Again, kindly come to once.
First you finish the judgment.
One second, I'll give the date. Page 8 lo icharu date. No. Our screening committee sat on 16/11/22.
16/11?
22.
22.
Yes, ma'am. So promotions were given, if I am correct, my lord, promotions were given only after 16/11/22. They were assigned dates, my lord, of 2017.
Where is that postings? Now, have you filed?
I have not filed, right? In the CN.
One second, I'll just show to you.
By virtue of the recommendation of the
How do you decide this issue without there being material? When were they promoted? Is it violation of code section? Violation of the rule 3 of state service rules? Your case is that the unofficial response were promoted contrary to rule 3.
Yes,
of service rules, which shows the dates of promotion. Your appointment is on 19/1/2018. When were they promoted?
They were given, kindly see page 8 at top. Kindly see the
Which page?
counter affidavit. Page 8 top. They say so, Milord.
Yes, counter page
8.
8 is.
Milord, I'll just read. Milord, from page 6, bottom onwards.
Yes.
It is respectfully submitted that similar action has been taken to streamline the ad hoc promotions. Earlier to this, my lord, there were ad hoc promotees in Deputy Superintendent of Civil from 2/6/2014 to 31/8/2021.
Yes.
Lord's got that. based on the above final rectified integrated seniority list of inspectors issued in GO 153 dated 5/10/2018, read with this office memorandum dated 13.
No, what is the relief sought in writ petition? Read the relief.
In my case, my lord.
Yes.
My lord, to
Declare the final seniority list.
yes,
One is the nature of writ of mandamus, but declaring the final seniority list
as
issued
illegal.
in GOMS number 74 dated 29/12/2022.
This is the seniority list which I am showing. This is the seniority list which I have shown to your lordships, my lord, at page 1 second. 45 it starts. Page 74, your lords got page 45.
45.
GO 74.
Yes.
My lord, in that, my lord, at page 46, paragraph 6,
Yes.
your lords got.
Read.
Accordingly, the screening committee, office of the DGP, by its proceedings dated 16/11/2022, approved the provisional seniority list of deputy superintendent of police from 2/6/2014 to 31/8/2021.
Yes.
That is, screening committee sat and they gave the what you call as notional dates. This is when, my lord, they were given notional dates with effect from, my lord, 2017.
Where is the 2017 promotion order?
There is no promotion in 2017, my lord. 2022, 16/11/2020.
Approve the provisional seniority list of deputy superintendent of police from 2/6/14 to 31/8/2021.
Yes.
Based on the final rectified integrated seniority list of inspector of police.
Already, go to, my lord, one paragraph above. Paragraph 5 also may be.
Yes.
Further, the Director General of Police, Hyderabad, in his proceedings dated 3/11/22, has constituted a screening committee to streamline the ad hoc promotions. I'll stop for a minute here. Earlier, they were on ad hoc promotion. I do not know whether I could make myself clear. Some persons, my lord, were on ad hoc promotion as deputy superintendent.
Yes.
Then, my lord, DG has constituted by his proceedings dated 3/11/2022 a screening committee. Screening committee met on 16/11
Yes.
and they have given them regular promotions, giving the retrospective dates as notional dates. That's how I can say. This
That
is
is your
what,
understanding. What was that?
this is what they say, my lord. This is the only, there is no separate orders, my lord. This is the order that by which, my lord, they were given.
Yes.
And by giving them
Now,
that,
have you filed any objections to the provisional seniority
yes,
list?
yes, my objections are also recorded. I'll just take your losses to the objections.
Yes.
1 second, Lord. I'll just, page 61. Kindly take to page 61.
Yes.
Serial number 41.
Yes. Read.
Lord, my objection is this. He has been originally appointed pursuant to notification dated. My objection I am reading.
Yes. Yes.
18 of 2011, dated 28/11/2011, wherein various posts have been advertised, including the DSP civil and deputy collector, but same was delayed due to litigation on deletion of 6 questions. And finally, as per the orders of the Honorable Supreme Court of India, main examination was held afresh on 20th of January 2014, and due to inordinate delay by Service Commission, results were published in October 2017. Kindly note that date. I am only saying I will not be asking for anything else. If I am given from October 2017 also, even ignoring my claim for seniority over those respondents to
Yes. Results were published on in October 2017.
and appointment orders were issued. But in my case, only from 19/1/2000. For all others, my lord,
Yes.
immediately were given in 2017.
All other categories
All other categories.
except DSP. Yes.
Yes, due to which nearly 80 promotees, I have stated saying that nearly 80 promotees have been shown above him in the provisional seniority list. The meantime, direct recruit vacancies were temporarily filled by promotees. This delay in his appointment as direct recruit DSP is purely administrative. Hence, his date of recruitment.
Sought to have been taken as 2013. What is this? Page 13. Next.
Yes,
page.
have been taken as 2030, have to be taken as 2013. That is date of preparation of the merit list or at least as appointment in October 2017. This is what I have asked for.
Yes, read further on.
As considered for other members allotted against other posts, but not 2018. The interstate seniority between direct recruiters and promotees has to be determined by their appointment in their respective quota by taking vacancies arising in the panel year in respect of promotees only, but not in the direct recruit quota. As per GOMS number 137, in every cycle of 10 vacancies, 1, 4 and 7th vacancies are to be filled by direct recruits and rest with promotees, whereas the cadre strength of DSPs has not been communicated and year-wise vacancies have not been calculated. Hence, the present fixation of seniority itself is illegal. Hence, placing the persons above him in direct recruitment vacancies is illegal as per the Honorable Supreme Court of India, and he should have been placed at serial number 96 instead of at serial number 176. This is my claim.
What is their answer?
Answer, my lord, again, go back to page 12.
Yes.
As per Rule 33 of the State and Subordinate Service Rules, 1996, the seniority of a person in a service class, category or grade shall, unless he has been reduced to a lower rank as punishment, be determined by the date of his first appointment to such service class, category or grade. As per Rule 16A of the same rules, a person appointed in accordance with rules by direct recruitment shall commence his probation from the date of joining duty. As per the above conditions in service rules, his date of appointment is to be considered from the date of issue of GOMS number 8 dated 19/1/2018, wherein he has been appointed as DSP by the government.
Yes.
The direct recruitees of 2012 batch has already been included in the seniority list of DSPs in GOMS number 187 department dated 29/11/2018, except the applicant and another individual appointed as DSP civil on 8/1/2018. No other direct recruits have been appointed as DSP civil from 2014 onwards. In the what they say is, after 2014 appointment, this is 2018. Therefore, we will show you here. And no
Yes.
direct recruits have been appointed as DSP from 2014. In the present provisional seniority list issued, regularization of services of DSP civil from 2014 onwards, as per the seniority list of inspectors of police issued by GO 153 dated 5/12/2018, has been confined to the vacancies arising in each panel year in the promotee quota only, and 91 vacancies existing out of 94 vacancies of direct recruit quota has been notified to TSPSC. No direct recruitment vacancies has been utilized for regularization of promotees. The services of the promotees, TSPs working against supernumerary posts and in the direct recruit vacancies on ad hoc basis have not been regularized. The applicant and another individual appointed as DSP civil have been given appropriate placement in the provisional seniority list issued now as per their entitlement, and no injustice has been done is the answer. That they don't saying that they have followed Rota rule of 1, 4 and 7.
Yes.
They say that we have placed, even in the counter they say that we have placed 70% of the persons who were given the benefit of promotions in the promotee quota are shown en bloc above the direct recruits for whom the notification was given way back in 2011. I just imagine a situation where that person gets the vacancy of 2017. I get the vacancy of 2011. But I am shown junior to him because there was some delay in issuing appointment order to me while all others were given appointment orders in 2017. Munad, in 2017, 80%, Munad, here my...
Only 2 months delay.
2 months.
October, January, 3 months.
81 persons were placed above me. This is
81 were promoted in which year?
Munad, they were promoted on 16/11/2022. 16/11/22.
Subsequent to your appointment order.
Subsequent to my appointment order, my lord.
Yes.
A person who was appointed regularly subsequent to my appointment on 16/11/2022 not sits over me. And he is given the benefit from February 2017. I have been given the seniority from 19/1/2018.
Shows that benefit was February 2017 onwards.
Yes, my lord. Kindly again go to final seniority list, which I filed at page 45.
Yes. Yes.
Final seniority list, page 45 to 75. My lord, take to my lord page 70. I have shown, I have been given from 19/1/2018.
That is, yes, yes, that is clear.
No?
What is this subsequently her technical resignation accepted by the government for GORT number? Your resignation?
No, not, this is not for me, my lord. This is for Alekhya Balla.
Oh, not yours. Right. Right.
Then kindly go to page 68.
Yes.
They were given from 1/2/2017, 1/3/2017, 1/4/2017.
Yes.
This is what I say. They were given this benefit by proceedings dated 16/11/2022.
Even you have been appointed along with your batchmates.
Yes.
Even then you won't get this benefit. Because they were appointed in 2017, March, January, February.
That's what.
February, March and April.
But I get a different benefit in the sense that
You have to satisfy this, where is the violation of Rule 3?
this is what
147.
They
You
don't-
have to establish that.
they have not shown. But again, they say that some persons were appointed prior to 2014
Yes.
as direct recruit DSPs.
Yes.
After 2014, I was the first person to be appointed. Another lady, she left the job.
Right.
I was the first person to be appointed as DSP. Question is, I should be appointed in terms of note under Rule 3 or not?
Yes.
If I am entitled to. They must show me in the first available vacancy.
Now read the note. The note, this is the note. Yes, 1, 3 and
1, 4 and 7.
1, 4 and 7. Yes, yes, you're right.
In every cycle of 10 vacancies, so I must be taken in the first cycle.
Yes, yes.
I must be taken in the first cycle. And in the first cycle of 10 vacancies, I should be shown it. This is what the Honorable Supreme Court also says. You cannot bunch them. And as a bundle, my lord, you can't show them against. This is the judgment, my lord, which my learned friend relies upon.
Yes, yes. Yes.
And he files.
Yes.
I am only, that one judgment is conclusive, is my, that is also a police department, if I am correct. I just again come. Yes, that is also a police department.
88.
Police department.
No, no, no. It is not police department.
1 second.
ACO.
Department, I am trying to see whether it is what department it is.
Appointed as ACOs. What is meant by ACO?
Punjab Civil Service Officer, PCS. That is not deputy collectors.
ACO means assistant?
No?
Assistant Consultation Officers. Page 88, para 3.1.
Page 88.
88 is the judgment, first page. The writ petitioners who were promoted to the post of assistant consolidation
No,
officers.
I am relying upon page 53.
Page 53. Oh, yes, yes. You are relying on their judgment. They have cited. This is PCS officers.
He is Punjab Civil Service Officer.
Yes.
That is my lord, DSPs. DSPs, my lord.
So they have to follow note 1.
Note 1 they have not followed. Note has not been followed. They state in their counter affidavit very clearly saying that we have bunched in their counter affidavit. This is the lacuna that I am pointing out. They admit that. This judgment, my lord, sorry, my lord, if your lords may, again at page 67,
Yes.
promotees en bloc above the direct recruits. That by getting appointment orders, can I read page 67 again?
Yes.
That by getting appointment orders ahead of direct recruits, promotees have already enjoyed more perks than the direct recruits by way of pay, etc. This became possible because the selection process of promotees was shorter as compared with that of the direct recruits. The injustice to direct recruits cannot be compounded. That is, not made more, compounded
Yes.
by relegating them in the matter of seniority also, by placing the promotees en bloc above the direct recruits. This is what my objection. Again come to my lord, last paragraph, where they have, my lord, kindly come to page 70,
70?
page 70, my lord.
Yes.
Kindly come to bottom. We have also referred to the decisions rendered by this court. This court said that rota and quota, your lords, but
Yes.
rota is not this vacancies being
30 and 30, 70.
no, quota is 30.
Nota, I mean, yes.
That is first vacancy to go to someone.
Note.
Yes, note. Can I just read again? We have
Yes.
also referred to the decisions rendered by this court. This court said that rota and quota must necessarily be reflected. Kindly underline that, my lord.
Yes.
Reflected in the seniority list. And any seniority list prepared in violation of rota and quota is bound to be negated. But, no other clear decision is required than not this decision. The action of the respondents in determining the seniority is clearly in total disregard of rota quota prescribed in Rule 18 of 1976 rules. The action is therefore clearly contrary to the law laid down by this court. Thus, we hold that the action of the state is contrary to 76 rules. Seniority must be based on a collective interpretation of Rule 18 and 21. That action of the authorities is in negation of Rule 18 of 1976 rules in determining the seniority by impugned order. Since the action is contrary to law laid down by this court, we have no hesitation in allowing the appeal and grant relief as paid for by the appellant. We therefore issue a writ of mandamus to the respondents to prepare the seniority list of the appellants who belong to PCS executive branch. EB is executive branch.
Yes.
In accordance with Rule 18, read with Rule 21 of the rules, by fixing seniority according to, again, my lord, roster prescribed. Rota roster. Under Rule 18 of 1976 rules, then, my lord, that is in their discretion, they have given time. This is all the case about, my lord.
Yes. GP.
If for any reason, if your lordship feels,
Maybe. So far as the appointments and seniorities are both are different. My submission is, since there are vacancies available in the year 2014 onwards, but for administrative exigencies, the department has been taken a step to promote the eligible candidates on ad hoc basis. Since there is a ban in the year 2014 for promotion, effecting promotion, regular promotions. And subsequently, the persons who have been appointed on ad hoc basis, a committee was formed by virtue of the order passed by this Honorable Court in WP number 14878 of 2020. I referred in page 5, what the Honorable Court said in page 5, third
Yes.
parameter. Pending further orders, the respondent 1 and 3 are permitted to undertake only regular promotions to the post of personal SPs and Superintendent of Police, conferred IPS and ex-cadres, and this exercise shall be completed within 3 weeks from the date of receipt of a copy of this order. Any such promotions made shall abide by the result of the WPs filed in this court challenging the final seniority list prepared by the state of AP in the cadres of Deputy Superintendent of Police, non-cadre, Additional Superintendent of Police also, and Superintendent of Police NC. The persons who have secured interim orders not to revert them in those WPs shall, however, not be disturbed. Therefore, to enable to effect regular promotions to the above categories, the government-wide GORT number 247, Home Services dated 10/2/2021, has constituted a screening committee to streamline the ad hoc promotions issued in the categories of SPs, non-cadre, and additional SPs in Telangana state from 2014 onwards. The screening committee is constituted by the government after examining the posts allotted to Telangana state during bifurcation and posts sanctioned subsequently in both the above categories from time to time in Telangana state, and the service categories from the time to service records of each individuals have made its recommendation for inclusion of eligible officers in the year-wise panel from 2013-14 part to 2019-2020. The recommendation of the screening committee was accepted by the government of TS in GMS number 34, home dated 23/3/2021, and all the ad hoc promotions in category of Superintendent of Police, NC, and Additional Superintendent of Police were regularized from the panel year 2014-15 part to 19-20 from the respective lower category as per the GOs issued by the government and of AP, and assigned a date in the vacancies existing in Telangana state from 2/6/2014 till 31/8/2020. White GMS number 37 and GMS number 38 dated so respectively. Thereafter, regular promotions to the above categories were also completed for the panel year 2021, and compliance report was sent to the Honorable High Court in this office letter dated 15/6/2021. My submission, even at the time of constituting a committee, they have taken into consideration various aspects in the affecting promotions. Page 7, you will also make kindly see for a moment. The committee has married the committee members in the table.
Yes, right.
And then the committee was instructed to scrutinize the following aspects while making the recommendations. Cadre strength allocated to Telangana state in final bifurcation, number of persons allocated to Telangana state in the rank of Deputy Superintendent of Police Civil, seniority list of officers, and number 4, vacancy position including number of posts newly sanctioned in the Telangana state in subsequent panel years, as well as retirement, promotions, death, so and so. Fifth, panel year-wise calculations of vacancies from 2/6/2014 onwards till panel year 2021. Eligibility of officers in the respective panels for a regularization promotion with regard to minimum required service as per special service rules, and currency of punishment, details of disciplinary rules. Various measurements have been taken before giving a regulation of their services. According to the recommendations of this screening committee, the persons who are promoted on ad hoc basis in the year 2014 onwards, they have given a date, regularized their services in a particular year according to the availability of vacancies in the panel years. Therefore, they were issued a seniority list according to them. The unofficial respondents, before your lordship, were placed at serial number 96. Your lordship can see in the page number 68 in the.
No, where are those promotions? In which year, how many? Tell us the calculation of that particular panel year.
Yes, that is
14, 15,
shown,
15,
page
16,
number
16,
13.
17.
Page 13.
Yes.
So, page 13, a table has given.
Yes.
Year-wise panel, 13 and 14. Sanction strength. For example, the sanction strength 242, direct recruitment 73, PR 169, actual strength 190, DR 49, PR 141, vacancies existing on so and so 52, DR 24 and PR 28, arising during panel year 6 and DR so and so. Total 58, direct recruitment 24.
So this particular 13, 14, 6 were promoted.
Yes,
only DR quota 0.
Yes, Millard.
Promotion quota 6.
For the reason, Millard, there is no direct recruitment, Millard, from the year 2014 till the petitioner appointment. Therefore, as per the screening committee recommendations and year-wise panel has been prepared, and according to the recommendations of the screening committee.
So this demonstrate is all these.
Yes, Milord. In the 2014-15 and likewise, Milord, they have given statements, Milord. How many people have been given?
2015-16.
Yes.
One DR, direct recruiting, one post was filled up. Say 16-17, 21 posts were filled up.
This post is arranged, Milord. Arranged vacancy.
Yes. Yes. Then according to senior, now 15-16 one vacancy is available. DR quota.
Vacancy is available, but the recruitment, the notification issued subsequently. Yes, yes, Milord. Therefore, Milord, my humble submission is the persons, Milord, who are regularized their services in the cadre of DSPs are given Milord appropriate placement in the seniority list.
What about that principal note?
Milord, since Milord, there is no direct recruitment, Milord, since 2014. Milord, according to the regularization of his services, Milord, the department has placed it in appropriate place, Milord, in the seniority list. Lordship can listen, this appointment is 19/1/2008. Wherein the result of that notification has been pronounced, released in the month of October 2017. After verifications and
that is true, we are not going in that aspect.
Yes, Milord. And he was appointed on 19/1/2018, and his services were regularized from that date onwards. Since Milord, there is no regular appointment.
Contention is that there is a violation of note 147.
So far as the Milord,
so according to him, yes.
My learned friend has already, senior counsel has been already read Milord page 10, para 6 Milord.
Yes.
In reply to para 5.
Yes, read.
In reply to para 5 of the affidavit, it is submitted that the contention made by the applicant that the placing his name below the promotees who are appointed temporarily is illegal and arbitrary is not correct. The
Now read this rule, rule 3 of police service rules.
Yes, Milord. In the Milord, so far as the preparation of seniority list is concerned, Milord, Lord Smith is stated in para, Milord, second para in page 11, Milord, Lord Smith mechanism.
Yes.
The Milord, my senior counsel was read about half of the para, Milord. Hence,
read second para.
However, due to not undertaking direct recruitment on regular basis, all the earmarked vacancies in direct recruit quota is being carried forward without filling up and being notified to Service Commission for filling up the same by conducting recruitment as and when taken up by the Government Public Service Commission. In the event the vacancies are filled by promotion on administrative exigency, such promotions are treated purely on ad hoc basis without any right either for regularization of service in the category or for counting seniority for further promotion and liable for reversion to lower category without any notice. Insofar as the present case is concerned,
as per the contents of the petitioner, he is entitled because, as per your counter, this page 13, DR vacancy of 2015-2016, first vacancy.
Yes.
Yes.
But Milord, my humble submission is there is no recruitment, Milord, direct recruitment from 2014 Milord till 2017.
True, but how can you regularize their services who are promoted on ad hoc basis?
Yes, Milord. Even then, Milord, they were promoted in the year 2014, but they have not given Milord assigned the seniority.
On ad hoc basis only.
Yes, Milord, that is true. But they have not assigned seniority from their original ad hoc promotion date in the year 2014. But they are given only in the year 2017. After preparation of panels, Milord, and taking the consideration of Milord, their eligibility.
Read further also, page 11, para 2.
Hence, logically, either the direct recruits or the promotees shall be shown as a bunch in the seniority list by applying Rule 33A of
As a
State
bunch in the seniority list by applying Rule 33.
Seniority applying Rule 33A of State and Subordinate Service Rules 1996, which specifies that seniority of a person shall be determined from the date of his first appointment to the service. Therefore, there is no irregularity in showing promotees en bloc in the seniority
So
list.
you are
as
admitting
they
that they are shown en bloc in the seniority
in the
list.
seniority list as they have occupied post meant for their quota only, and the published seniority list is the outcome of year-wise panels only. And it is next parameter. It is respectfully submitted that the applicant has simply presumed that no year-wise panels have been prepared, taking into consideration of all the arrays and vacancies in the particular year. It is submitted that the final seniority list published do not reflect year-wise panels, except the dates assigned to individual officers. It is submitted that the screening committee has gone through the year-wise cadre strength of DSP, civil, DR quota, PR quota, and number of vacancies working and vacancies arose in respective
Please
quotas.
clarify this Rule 3 and the judgment. Page 50. Page 53, you have filed this judgment.
Yes. So far as the Rule 3 is concerned,
No, how do you justify your action in the light of the judgment?
in fact, the judgment was filed by my predecessor.
By you only.
Continuation of the office.
I have seen in the marking also. Well, so far as the rule is concerned, I'll.
Page
Rule
70,
3.
last para.
We have also referred to the decisions. All the earlier decisions were referred.
Yes,
We have
we have also referred to the decisions rendered by this court.
This court said,
This court
yes,
said rota and quota must be necessarily be reflected in the seniority list, and any seniority list prepared in violation of rota quota is bound to be negated. The action of the respondent in determining the seniority is clearly in total disregard of rota quota prescribed in Rule 18 of the 1976 rules. The action is therefore clearly contrary to the law laid down by the. My submission will not in the so far as the